application and appeal in the matter of Kate McIver Skin Ltd and another, and yours naturally, yours limited.
My lady, my lords,
Yes,
I appear on behalf of the appellant. My learned friend Mr Metcalfe appears on behalf of the respondent. And this is my appeal against the order and judgment of His Honour Judge Hacon, dated 26th of April 2023.
Yes.
In terms of timetabling, I think I'll be about an hour and a half, give or take a few minutes either way. My learned friend estimates about an hour and a half to 2 hours, and then I envisage perhaps a brief reply.
Well, we thought it'd probably tip into the afternoon, but probably not much more.
Yes, so that's roughly where the timetable takes us.
Yes. Well, if it's of any assistance to reinforce your timetable, we've had the opportunity of reading the papers. So we've read the judgments, read the skeleton arguments, and I think we've all, to a different degree and different bits, dipped into the papers also.
Very grateful, my lady. In terms of the documents, hopefully you have a core bundle, an authorities bundle, and a supplemental bundle.
Yes.
There has been some back and forth about the supplemental bundle. There is an application for permission to rely on it. The position is, the view on this side of the room is that all the documents don't meet the strict test of necessity, but if my learner friend wants them in, then we're not opposing permission. So I don't propose to waste your
No,
your
very
time.
pragmatic and very sensible. So if permission is needed, it's granted.
There are some extra documents to go at the back, which should be sitting on.
Yes,
the
I
desk
see
now.
this. It's a bit of transcript.
Yes, a touch of transcript and my skeleton from below, just so the court has.
And where would you like us to pop those?
They go to the back of the supplemental because the pagination runs on.
Thank you. We'll do that.
I think my learner friend wishes to refer to the transcript, and I just wanted my arguments before the court in case anyone says it was or was not argued.
We'll just put those in before you embark on your submissions.
Grateful. So the structure of my appeal will be that I will talk very briefly about the background, and then deal with certain items of law and principle, and then I will take my grounds 1, 2, 3, and 4. They deal with goodwill in passing off, misrepresentation, damage, and then there's a discrete copyright point as ground 4. My learned friend has a respondent's notice in, which has 3 additional grounds relating to goodwill, and I will deal with them on goodwill, and a 4th additional ground relating to damage, which I will deal with as I go through damage.
Yes. Well, I think that's a sensible way to do it. Thank you.
So in terms of the background, I've set out in brief form the background at paragraph 7 to 22 of my appeal skeleton. In essence, there was a white label agreement between Ms Tang and then later the respondent to sell some of this product that has been called elixir, but the judge referred to as the Tang formulation. And I would invite the court to think of it as the Tang formulation because the liquid doesn't have the word elixir written on, and it's very important to distinguish between the brand it was sold under and the product itself. Because the way the respondent has put its case is talking about the elixir serum, regardless of how it was packaged up. So I'm going to refer to the Tang formulation. So the Tang formulation was sold under a white label agreement to the appellant, well, originally the appellant's predecessor in title, Ms Diamond, who has sadly passed away, and then the appellant, and that was then sold on. Initially, some of it, a small amount, was branded elixir, and then after that there was a point where certain labels were put on which had secret weapon, and the brand used was secret weapon. In about October of 2018, the appellant started looking for alternative formulators and alternative formulations of the product.
Yeah, I'm sorry to interrupt you when you've only just started, but one of the problems I've found in getting to grips with this case is finding in the bundles the various different labels that were used at different stages, which are referred to by the judge in the judgment. So one thing I would find very helpful, and I'm sure my colleagues would find helpful as well, is if at each stage you could take us to the relevant label.
Yes, my lord, I will do that, and I have that in my note.
So we need to start with what the judge refers to as the, I think he calls it the original label.
Would it assist your lordship to see them now?
Yes, please.
The first label, which I think is the original label, is on page 153, which should be in tab 15.
No, that's not the original label. I found that. My understanding, and of course, it may be that I've misunderstood, in which case please do tell me. But my understanding is that that's what the judge calls the first McIver label in paragraph 15.
My lord, yes.
But chronologically speaking, that's not the first relevant label. The first relevant label is the one the judge calls the original label in paragraph 11.
My lord, I may have misunderstood that. I'll ask my solicitor to look for that one. One of the things I will say is that that label has never been put forward as having any goodwill or a misrepresentation, and my learned friend relied on the label that I've just taken.
Forgive me, you may be right about that, but at this stage, all I'm trying to do is identify what it is that the judge is talking about. No criticism to anybody, but we don't have any pictures in the judgment, and we don't have any pictures in the skeleton arguments. But it is important in these kind of cases for the court to see the labelling that has been used.
My solicitor will look for that, and if it's not in the bundle, then we will arrange for some kind of copy. I'll have a good look over the short.
Very good. That's extremely helpful. Thank you. So what you've just taken us to at page 153, as I understand it, and as I say, you know better than I do, so please correct me if I've got the wrong end of the stick. But as I understand it, 153 is what the judge calls the first McIver label, and that's paragraph 15 of the judgment. That
is right. I've been maybe misremembering them without looking at the right paragraph, but I will look for the original judgment, the original label, and we'll get something agreed.
Thank you.
So in about October, there was a move away from Ms Tang, or there was the starting point of moving away. And in December, a new product was launched, which had been reformulated and produced by a third party called Pelham. So that's in essence the background. A white labelling arrangement that broke down. The reasons given for the breakdown were price and also some concerns about quality.
Yes, but by that point in the chronology, your clients had moved on to what the judge calls the second McIver label. That's paragraph 24 of the judgment.
Yes, that is in the chronology. The first label appears.
Excuse me.
Forgive me, there is a chronology, tab 9. I don't know if you'll have seen that.
Yeah.
The first label appears around April 2018 till June 2018.
Yes.
The first label is the one that I took your lordship to a moment ago. The chronology, this is on page 82.
Mm-hmm.
It's in bold.
Yep.
And then the second label, which is the one which I'll go to in a moment, but that was 20th of June to December 2018.
Indeed so, yes. And so where do we find that one in the Bible?
It's just behind the one I've been to a moment ago. It is page, tab 12, page 155.
Yeah.
It's not the best copy in the world.
No, all right.
But
it's that again is what I thought. That makes sense, all right.
Moving to my next topic, which is the relevant law and principle to apply.
Well, I'm sorry to just pursue this theme, but the other one that I wanted to see is
4th, isn't it?
Sorry, I've now lost the reference. Yes, because there's the one the judge refers to as having the word original on it, and I'm struggling to find that.
My lord, if I could invite you to turn up to page 329 in the bundle, which I think will be in tab 18. No, tab 18 or tab 19, forgive me, mine's bookmarked, I'm electronic.
329.
329.
So that'll be in the supplemental.
Yes.
329 is social media. Social media.
Three, 325.
Thank you.
My numbering's all right. I had an early electronic version, and it's now got different numbering. So I'm going to the the paper one now.
Oh well, I think
325 has
photographs of the
Yes.
elixir.
Yes.
A secret weapon serum, I should call it,
Yes.
as it now was.
Yeah.
So that is how it was sold thereafter. So that is what I say is a separate, distinct brand.
Yeah. But that's what the judge is talking about when he talks about it having the word original on it.
Yes.
Yeah, understood. Thank you.
Okay.
Yes, one of them has original on, the other one, there are two separate formulations.
Yeah, it's particularly the one on the left
Yes.
that he's talking about. Yeah, understood. Thank you.
So moving to law and principle, my first point is on what happens in IPEC. IPEC has special pleading and procedural rules, and the first of those is that the party needs to plead their argument. Facts, and that's from the 6th of April 21. And if not there, then the judge ought to disregard them.
Yeah, but the problem is that this case was transferred into IPEC after the pleadings were closed.
Yes, my lord, that's my learned friend's point. But what I'm not saying is that there are tiny points that my learned friend could have made, or conclusions or reasons. It's that the way the judge analysed the case was completely different to the one that my learned friend argued.
Well, indeed so. I take that point, but I don't understand your reliance upon the special rules in IPEC in circumstances where the case was pleaded pre-IPEC, transferred in, and no order was made for it to be repleaded.
My lord, if I rely on that, but I also rely on the more general principle of civil procedure in this country.
Well, which is the case has to be pleaded,
yes,
at least to the ordinary elementary standard.
Yes.
Yes.
And that's my next point on the note. So the IPEC rules, which I say are there for a reason, and it's importantly, you're shut out from bringing in anything that wasn't decided at the CMC in the issues, except in exceptional circumstances. But more generally, in adversarial proceedings in England and Wales, it's for the parties to define the issues and the judge to adjudicate on the issues. If a judge has a third way, it's not open to the judge to run the third way.
Yeah.
That's an inquisitorial function you find on the continent, but not here. That's my procedural points.
Yeah. My
main point of substance on the law is about record. That is tab 8 in the authorities. It starts on page 117 of the bundle number 491 of the internal report number. The relevant passage is on page 125 of the bundle number, or 499 of the report number. And that is my the key passage of law that I rely on.
Do you want us to read through the sidebar passage?
Yes, my lady, rather than me read it out loud. And
Certainly.
so from that, I invite the court to draw 4 points. Firstly, passing off is really about facts, and referring to other authorities is of little assistance. The other 3 points are what is called the classic trinity, and that they are, firstly, a claimant must have goodwill, and that goodwill must be associated with something. And Lord Oliver describes it as a mark or get-up, but it has to be associated with something in the minds of the purchasing public. Secondly, there must be a misrepresentation which is likely to deceive the same purchasing public into believing that the goods of the claimant are the goods of the defendant, the goods of the claimant. And thirdly, there must be consequent damage to the goodwill which has been caused by the misbelief suffered by the relevant consumer. The essential characteristic of the misrepresentation in passing off in my submission is that it is made by trading off on the association in the mind of the public. And that is what distinguishes passing off from other torts where one trader might make a misrepresentation about another. For example, if a trader were to say, my competitor is insolvent, that wouldn't be passing off. It might be something else. It might be malicious falsehood. It will damage goodwill, but it wouldn't be passing off. So it's not just any old misrepresentation. It is a specific kind of misrepresentation that is made by trading off the association. Now, the reason I spend so much time on this case, which would normally be just put before the judge and accepted, is that my learned friend seems to be suggesting that either it's wrongly decided or it should be very narrowly confined to cases involving a badge or like get-up, as in the characteristics of the product. And
I don't think he's suggesting anything of the sort. I think what Mr. Metcalfe is suggesting is that Lord Oliver's formulation is not to be taken as if it were a statute, and is merely an attempt to identify common features of the most common form of passing off. But passing off is not limited to the most common form, he argues, and you can see this from earlier case law, notably of the House of Lords itself, which the House of Lords in Reckitt did not purport to depart from.
My lord, I think the essential point my learned friend is making is that the idea is you don't need some kind of association with the goodwill. So you just have goodwill on its own, and that's all you need. And as soon as someone starts making misrepresentations, then it's passing off. And I say that's not right. The association is essential. It doesn't have to be a badge. It can be with. It must be with something. Otherwise, how can the purchaser be deceived?
Well, would you dissent from the proposition that it's essentially a question of causation? There must be goodwill, there must be a misrepresentation, and there must be damage. And the damage must be caused by the misrepresentation. But do we need any more than that?
Well, in my submission, if the causation point turns on an association, there's a lot of overlap in the three elements of the classic trinity, but it could be put as a matter of causation, where the cause of the damage is the misrepresentation plus the association. But the association is still, in my submission, an essential part, wherever you put it in the trinity.
Do you rely on the words attached to the goods or services which he supplies for your point about association? Just not quite sure whether. Just below letter E on page 499.
Yes, my lord. So the goodwill attached to the goods and services, yes, but in the mind of the purchasing public. So it's attached in the mind of the purchasing public. So there is an attachment between the goodwill and the goods and services in the mind of the purchasing public.
All right. And how would, I mean, this, I'm sure you're going to come to this, but at some stage we'll need to understand how you fit within that conception the case is up to and including Bristol Conservatories.
My lord, I can come to that now. And what I say about Bristol Conservatories is, firstly, there was something which could be attached in the minds of the goods and services in Bristol Conservatories. There was the claimant's portfolio of photographs, which had been taken from the claimant by the salesman who went to the defendant. But one, I would urge there's some caution to be had with Bristol Conservatories, because it's a strikeout case. It's an appeal from a strikeout case. So all that it determined was whether the proposition was arguable. It did that, obviously, as it always happens, on assumed facts. And there was no trial inquiry, as far as I can see, later on, as to what the real case on goodwill was.
Well, you're absolutely right to say it was a strikeout case, and you're also absolutely right that there's no report of any subsequent trial decision. And I completely accept your point that one always has to be careful with strikeout cases. But the reasoning of the Court of Appeal in that case was that, assuming the facts alleged were true, the case of passing off was made out as a matter of law.
Yes, that's right, my lord. But there was an association with something. There was a thing that the goodwill could be associated with.
Well, what in your submission was the goodwill associated with, and what do you rely upon in the judgment in support of that?
The portfolio of photographs which were alleged to have been taken, which were then showed to customers, to potential customers.
Right, and the people to whom they were being shown those photographs had never seen them before. So what exactly is the association you're relying on?
Was that the ratio? I don't think there was any finding on what had never.
Because it's implicit in the factual scenario. I mean, by all means, let's look at it. But the whole point is the defendants were showing photographs of the claimant's conservatories to customers whom the defendants were hoping to get business from. There was never any suggestion that those customers had seen the claimant's conservatories. They simply were being shown, here is a photograph of what we can supply you. And the implicit representation is, if you buy from us, you're getting what you see in this photograph. And that was false.
My Lord, if we can go to page 106 of the authorities bundle in tab 7, which is 458 of the
Did you say 106?
106 of the red numbering in the bottom. Yes. So it sets out the amendments, the factual amendments to the case, and what the first of those is that there were a nationally known manufacturer of conservatories that have certain unique features of design and structure and
I
construction.
beg your pardon, it's my fault, but I haven't found where you were.
It's page 458 of the internal numbering on the report, or
Yes.
106 of the
Right.
and
you're aware
line
of
20.
You're at line 20, did you say?
Yeah.
Yes, but it might be helpful to start at the top of the page, because you can see there what gave rise to the amendments. So what Lord Justice Ralph Gibson says there is, he says, allegations of the stated claim included reference to a specific occasion on 9th December 1987 when Mr. Rickard met a Mr. Osborne, who was an inquiry agent instructed by the plaintiffs, who pretended to be a customer for the conservatory. It said on this occasion, Mr. Rickard, in substance, represented that the portfolio of photographs constituted, quote, a sample of what custom built do, and that as such, it was, quote, pretty good work. So what you see there is that there's no suggestion that Mr. Osborne would have had any knowledge whatsoever of the work of the plaintiffs. He was an inquiry agent. And the whole point is that what it shows is that the method of business being adopted by the defendants was to use the photographs to people who might never have seen the claimant's work to say, here's what we can do for you.
Oh, my Lord, that one inquiry agent might never have been a customer is a relevant fact, but that doesn't mean there aren't potential customers, which is to whom the representations are made, who might have known about the claimant or seen their photographs or known about their conservatories.
Well, I take your point. One doesn't exclude the possibility that some of the potential customers for the defendant might have been previously aware of the claimants. I take that point. But where in the reasoning is that treated as the foundation for the claim in the legal analysis? See, I'm looking at page 463 in the report, where, having been through the authorities, Lord Justice Ralph Gibson says at line 34, he says, the principle applied in that case seems to me to be well applicable to the facts alleged by the plaintiffs. Custom built, by their misrepresentations, were seeking to induce customers to purchase conservatories from them in order to get a conservatory from the commercial source who had designed and constructed the conservatories shown in the photographs. That was the purpose of Custom Built in showing the photographs and in claiming to have designed and made the conservatories there shown. If a customer ordered a conservatory from Custom Built in response to the misrepresentation, as it was the intention of Custom Built that he should, Custom Built would supply conservatories not of the stated source, but of their own manufacture. Lord Green thought that that would be passing off with respect, so do I. Now, is it your submission that that reasoning is in some way dependent upon the potential customers having previous familiarity with the claimant's conservatories, because I'm struggling to see that anywhere expressed in the reasoning.
My lord, the reason I say it's necessary to be careful with the cases, in a trial, there would have been a lot more submissions on the facts and how they fit in. And yes, I take your lordship's point that the assumed facts are the facts that the judge worked on, but we don't have a full list of the pleadings that was before the court. So in my submission, there was still something which was associated in the mind of the public with the goodwill in that case. But it may be that if your lordship's not with me on that, my lady, not with me on that, it may be that it does come down to a causation point. But in this case, the case we're dealing with today, I would make a number of points as to why this doesn't apply. Firstly, there was no suggestion of that goodwill per se. I mean, I'm going to go into pleadings in a minute. Goodwill per se was what sustained the passing off action. And secondly, the misrepresentations that were made according to the pleadings were made by using specific marks rather than which it was said that goodwill was attached to, rather than in a more general sense. So that's what I say about Bristol Conservatories.
Yes, well, you make an important point about the pleadings. So is this a good moment to look at them?
Yes, my lord.
Unless there's more on the cases you want to look at.
I just had two other very brief points on the two other cases. My
Sure,
lord,
sure. By all means, let's do that first.
First,
Yes.
and I'm not going to go to the authority, but Plowman, again, I urge caution, because that isn't even an appeal from a trial. It's a second appeal from a quantum case. So liability.
Which case?
Or Plowman, it's number 5 in the authorities bundle.
Thank you.
And it was a second appeal from a quantum case. So I would urge caution in applying the reasoning to what is in effect a liability trial. And ScanSafe.
Sorry, can you help me on that? I mean, I appreciate. Please understand. We're always grateful to advocates who are concise in their submissions, rather than going on at length. So it's excellent you're taking matters shortly, but I'm a little struggling to understand the point you just made. Why is the fact that it comes out on quantum as opposed to liability in some way a point against its force as an authority? I'm struggling to understand that.
Because of what was decided was not the issue that the court is looking at today. Looking at causation in a quantum case. So at most, it's obvious.
Well, but I don't quite understand that. Because the question was at issue in the Court of Appeal was a liability question. I mean, yes, you're absolutely right. It arose in the context of an inquiry as to damages. The question was, could the court draw an inference that people were deceived? Answer, yes, they could. And that's a liability issue.
Well, my lord, yes, but that fact had already been established by the trial below. I wasn't proposing to spend too long on this point, because my principal submission on Plowman, along with exercise and caution, is that it is they turn on their facts. In that case, there was an association with some test results, or there was a facet that was by which the representation was made, and there's nothing like that in this case, so it's distinguishable on that ground.
All right, that is a point that I do understand. Thank you.
And ScanSafe.
Tab. Thank you.
Again, I don't want to go into too much detail. My objection to this authority is that it was an injunction case decided on the balance of convenience, where the judge at paragraph 87 on page 205 expressly said, although arguable, I do not regard this as anything approaching clear cut.
All right.
And it's a completely different case in my submission. So the basis of my appeal
Sorry,
on
just
my...
give me 1 minute to just glance at paragraph 87.
It's at the penultimate page of the tab.
Thank you, I have it. Yes, thank you.
So turning to my first ground, which is goodwill. The judgment, the paragraph of the judgment that I take issue with is paragraph 56 on page 102. Paragraph 55 before it sets out a finding that the judge and that the claimant, the respondent, had goodwill per se, and that it had been assigned to, sorry, Ms Tang had it and that it had been assigned. But 56, where the judge deals with my case, and the defendants pointed out that Ms Tang never traded under the names Kate McIver or Secret Weapon, never used any of the own brand labels used by Ms McIver, and never traded as the creator of the elixir serum. She did not. And I say the judge sort of stopped there and said, you haven't proved your case. But he didn't. He went on and said, but I fail to see the relevance. YNNY, the respondent's case, is that her business in the sales of the serum acquired goodwill, and that goodwill was associated in the public mind with the trade name elixir. I find that case established. So if we turn to the pleadings, the particulars of claim on page 115, paragraph 25,
Yeah.
we can see that the indications relied on in passing off little Roman 1 and little Roman 2 are reference to the unregistered trademarks, Kate McIver, Secret Weapon, the first label and the second label. Forgive me, my lady, I'm going to...
Sorry.
115 of the core bundle.
It's just my bundles aren't labelled for some reason, and so I keep picking up the wrong bundle. Page 111. I have it. Thank you.
115, forgive me, my lady.
Start.
This sets out the particulars of passing off by reference to the foregoing, which is the preceding paragraphs about the trade between the two. The claimant is the owner of valuable goodwill in the elixir serum, the Tang formulation, by reference to the unregistered trademarks, Kate McIver, Secret Weapon, and the first and second label. And then...
Yes, and the first label and the second label, those are what the judge calls the first McIver label and the second McIver.
Yes, that's right.
Yeah.
And in the next paragraph, it sort of says the same again, but goodwill as the originator of the elixir serum supplied to the first defendant under the unregistered trademarks. And it's the same unregistered trademarks. So those unregistered trademarks and the status or as originator are what the judge just rejected when he said she
yes,
did not.
but you say that, but what do we make of little Roman 2a, where they say that the claimant does not aver that the claimant's goodwill is held in the unregistered trademarks per se, but by reference to paragraphs 15 to 20, the elixir serum became associated with the unregistered trademark such that there arose goodwill separately to the first defendant's goodwill, and in that respect reliance were placed on inter alia Bristol conservatories.
That is still an association with the unregistered trademarks, which is set out in the previous paragraphs.
All right.
That was the pleaded case. And in the defence, on page 128. Paragraphs 32 to 34, there's a trenchant denial of those points.
I beg your pardon, can you give me the page again?
128, it's in tab 13, my lord.
Yeah, thank you.
And also in paragraph 36, although this is dealing with a different paragraph, the second sentence is, in particular, none of the defendant's goods bear the word elixir without admission as the ownership by the claimant of any goodwill in that sign. And the reply, paragraph 32, deals with those paragraphs. It's page 140 in tab 14. There's an admission that the claimant, Ms Tang, didn't sell goods directly under the relevant signs. And it's admitted that none of the defendants could use the word elixir. So that was the scope of the case on goodwill before the court. And that is what the CMC decided the issues would be. So if I can invite you to take up the supplemental bundle, tab 77.
I don't have tabs.
It is page 540, my lord. It should be towards the back.
Thank you.
So the third recital is, upon the issues to be determined at trial being identified in the schedule to the order.
Where are you? Page 549,
540, my lord.
540,
I think the pagination may be out slightly.
Oh no,
because
forgive me, I've forgotten. My electronic bundle is out.
The,
So
the list of issues starts in our bundle at 539.
Yeah, forgive me. I will.
While you're a page out all the way through.
So yes, the list of issues is 539, but just to go back to 536, the order itself recites that the issues have been determined or have been identified.
Thank you.
And then paragraph 1 says that they are the issues for the trial of liability. And then we see what the issues were on 539. And the first two issues are directly going back to the pleadings we just looked at. So my case on goodwill is that the response case just wasn't made out. The case that was pleaded and put before the court, and that everybody decided would be the issue looked at, wasn't made out.
Well, I understand that submission, but what do you say? I mean, and again, this ties in with the way the passing off case was pleaded in the particulars of claim. If you read on down after the issues about the false statements in 3 and 4, you get to 5, 6 and 7, whether the first defendant, Ms Diamond, have misrepresented that the origin of the first imitation, the second imitation, is the same as the elixir serum, and then whether the first defendant and Ms Diamond misrepresented that the second imitation secret weapon original is the elixir serum, and then 7, if so, whether such misrepresentation has caused the claim damage. So, as I understand it, and it may be this comes up under the heading of the respondent's notice, that the case on goodwill has to be, it is argued that the case on goodwill has to be understood in that light.
Well, what I would say is the case on goodwill and the second issue on goodwill is specifically about the claimant as originator of the elixir serum. So the misrepresentation case is understood in that light. So where it talks about same origin, it's about that goodwill, because that was the way the case was put.
Okay.
So in my submission, the judge should have stopped where I said he should have stopped, and that would have been the end of the case on passing off. My lord?
No, I'm just behind the curve. Are you saying, you're saying that the claimant had no goodwill as the originator of the elixir serum?
Yes.
Because?
She never traded as off that feature. Nobody thought she is the.
If the question is whether you're an originator, do you need to trade off a particular description?
Well, I would say yes, because there's no general tort of copying, or for a product, if it's not protected by a patent or some kind of enforceable confidential information, then a product people are entitled to copy a product. That's fair competition. It's competition.
Okay. And so you say that having knocked out 25(1), 2, and 3 of the amended particulars of claim, there's nothing left as a foundation for the goodwill which is being asserted here.
That's right, yes.
Okay, well, at least I've understood that.
I'm grateful. And just as a subsidiary point on the originator point, it was common ground that Ms Tang was a general white labeler. So in my submission, that takes away, she wasn't saying I'm the originator of this. In fact, she was selling it to anyone who would pay to put a white label on it. Now, to turn to my learned friend's arguments, he says at paragraph 43 of his skeleton that the pleading point is untenable because there was a case set out on trade under the relevant, the YNNY. Paragraph 43 is in tab 6. On page 60. Now, I say that point is wrong. Firstly, because I've already submitted that, I say that goodwill associated with something is an essential factor in the cause of action. It was an essential fact. And I also say that it conflates trade with goodwill. They're not the same thing. And trade is a necessary condition for goodwill, but it's not a sufficient one. There has to be sufficient trade to make some kind of association in the minds of the public. And that is, in my submission, particularly true for words that are descriptive or generic or quasi-descriptive or quasi-generic, which I submit in case of beauty products, skin serums, elixir is. And certainly, if it had been pleaded that the name elixir was going to be relied on as a brand, the case would have been run on the point of defence in a different way, because there would have been a challenge as to whether there could ever have been a secondary meaning associated with that, or some kind of distinctive character. But that wasn't run at trial because it was never an issue. It's unfair for my learned friend to take the point now. And his arguments on the law I've already dealt with in terms of I say that an association of some kind is necessary. Turning to the respondent's notice, which is on page 48 in tab 5. The grounds are, forgive me. The first ground is that the judge should have found that there was goodwill associated with this business of the sales of the serum per se, and without connecting it to a particular trade name. And the first point I make on that is that the submissions on the law I've already made. I say that there isn't an association necessary, or certainly on the facts of this case. And secondly, it wasn't pleaded. there was an express reliance on 4 separate markers and then this question of originator. So there was no case which said, and even if that's wrong, then we rely on just the goodwill. And in my submission, that is sufficient to dispose of the appeal on that basis. Ground 48, sorry, ground 2 on the respondent's notice, in essence, invites the court to add another unpleaded indication mark to the judges, the one the judge has already added, which is YNNY, or yours naturally, naturally yours. The points I would make on that: firstly, it's not pleaded. Secondly, it's not argued. It wasn't argued below. Thirdly, in my submission, it doesn't get him anywhere because nobody is suggesting that representations were made by using this particular trade name. Now, if I'm wrong about the necessity of an association, it doesn't add anything to the Elixir case anyway. So in my submission, it should just be disregarded. And the third of the goodwill grounds is that on the evidence, the judge ought to have found goodwill associated with the Elixir serum product and or the respondent as originator. Now, in my submission, the respondent as originator case has been rejected, and the judge, my learned friend, doesn't really identify the necessary parts in his skeleton.
Well, where do you say the judge rejects that case?
Well, in the paragraph I took your lordship to, paragraph 56 on page 102.
Well, he certainly says never traded as the creator of Elixir serum, and that's not in dispute. But where does he reject the case that she was in fact the creator of the Elixir serum? I thought he found that to be established.
I think I'm talking across purpose here, and I'm sorry if I haven't made myself clear. And if she has traded if she was the originator in my submission, that doesn't mean there's goodwill associated with it. Talking to my lord a moment ago about it, she was a white label. She never traded as the originator. She may have been the originator, but she never traded as the originator. And I say to generate goodwill in that association, one would have needed to trade off it. Because I say that trade is a necessary condition, if not a sufficient one. And I say paragraph 56 rejects that proposition.
Well, you're undoubtedly correct that the judge in paragraph 56 rejects any case based on the notion of trading off being the creator. Absolutely right. But that's not the point of the respondent's notice. I mean, the whole point of a response notice is to put forward additional grounds to those given by the judge. All right. So the jumping off point for paragraph 3 of the respondent's notice, as I understand it at the moment, is 2 findings of the judge, which I don't think you dispute. 1, that Ms Tang was in fact the originator. 2, that there was goodwill in the product. I don't think you challenge either of those 2 propositions. If I've understood correctly, your argument is that they're not enough. Is that right?
Well, yes, I would say that they're not enough, because for there to be something in the minds of the purchasing public identifying the product with a definitive commercial source, the public has to know about that thing. And the public can't know that Ms Tang or the respondent is the originator of the product unless she's marketing it on that basis.
What's the difference between that and Bristol Conservatories? Bristol Conservatories, no one would have known that Bristol Conservatories had built the conservatories that were shown. And it's part of Lord Oliver's formulation under his second point, that it's unnecessary for anybody to know even the identity of the plaintiff claimant.
On Lord Oliver's second point, I accept that it's unnecessary to know the identity. So you don't have to know who the claimant is, but you have to have an association with a definitive commercial source.
But if the facts of, forgive me, I just may not be understanding, if the facts of Bristol Conservatories had been slightly different, so that what was complained of was that representation or misrepresentation by the defendant was, we made these conservatories, rather than you will get these conservatories. Why wouldn't that be passing off?
Well, my lord, I don't know how that case was fully put. If I was pleading it, I would have set out that in the minds of the public, the conservatories or the features of the conservatories had been come associated with the minds of some of the purchasing public, such that a misrepresentation was made. But this is my learned friend putting forward a specific indicator that he says the respondent has goodwill associated with, but the association must be in the minds of the purchasing public. That's the way he's putting it. If whether I'm right or wrong about whether an association is necessary, that is what he is putting.
Okay. Now at this point, forgive me, I want to return to the legal proposition we were discussing earlier, because what this has helpfully illustrated is the purchase of your arguments on what you say the correct approach to the law is. And I understand your reliance upon Lord Oliver in Reckitt and Coleman, I get that point. But can we go back to what Lord Diplock had to say in the Advocat case, which we find in the authorities bundle at tab 6?
Yes, my lord.
And it's page 742 of the report, page 88 in the bundle. And it starts at, it's the passage at D to E, which is frequently cited. Spalding and Gamage in the later cases make it possible to identify 5 characteristics which must be present in order to create a valid cause of action for passing off. 1, a misrepresentation. 2, made by a trader in the course of trade. 3, to prospective customers his or ultimate consumers of goods or services supplied by him. 4, which is calculated to injure the business or goodwill of another trader in the sense that this is a reasonably foreseeable consequence. And 5, which causes actual damage to a business or goodwill of the trader by whom the action is brought, or in a quiescent action will probably do so. Now, the question that arises out of that is a twofold one. Firstly, I think you accept, but if you don't tell me, the Bristol Conservatories fits neatly within that formulation. And then the second part of the question is this: why does not respondent's notice paragraph 3 also fit within that formulation?
Well, firstly, my lord, I would agree that the Bristol Conservatories fits in with the formulation, but I would also say that the test given by Lord Diplock and the test given by Lord Oliver are the same, or the latter is a simplification or a refinement of that test, and that is part of the judgment of Sir Richard Scott in Dawn A Day case, which is in the authorities bundle at tab 9, and you will find that passage on page 178 of the red numbering, 700 of the internal report numbering.
Where are you on page 178?
Between lines 15 and 20, so line 17, I think.
Thank you. Thank you.
So Richard is talking. Yes, and then in the next point, starting at 25, he describes it as a refinement of the requirements down to 3. I think that is well established in this court, in other cases as well, such as Fade, I think.
Okay.
So that's what I say about that, my lord.
Right. And your answer to the second part of my question?
Well, if they're the same, then it's quite. There are 2 different tests, and they're ordered in different ways. And it may be that there's just a certain amount of overlap. But I say that in Lord Diplock's test, the misrepresentation, it still is carried out by the association. That's how the misrepresentation is made. And it may be that that comes into the calculated to deceive, the likely to deceive point, maybe a causation point, as my lord pointed out earlier.
Well, indeed. And I quite understand where you're coming from in terms of causation, but would you accept that certainly at the goodwill and misrepresentation stage, Lord Diplock doesn't speak in terms of association, does he?
He does not. I've been trying to put my appeal in the boxes set out by Lord Oliver, and as I understand the Advocar case test, they're just the same boxes but organised in a different way, and I could have put it the other way, but I haven't. So if it comes down to causation, then it may come down to causation, my lord.
Yeah.
So going back to the respondent's notice, I do say that there's no trade under those particular marks, but also the goodwill as the originator case must have been rejected because it's not accepted, and it's the claimant's case to prove its case. And the association with the product itself, in my submission, goodwill in the product, that's not what passing off is about. The products can be protected by particular features. So, for example, I think in the authority William Edge and Son, there's a discussion about a screwdriver with a particular handle, and that features of the product which are identifiable with the company can be protectable features in my submission, but just products per se, absent a particular feature that is identified in the minds of the consumer, there's no protection unless they're patented or covered by design rights or confidential information.
Well, that in itself is a controversial area of law, but I don't think we need to go there.
No, my lord, forgive me.
Because this is not a case about goodwill in the product per se.
That's right, but that's how I understand my learned friend point 3 on his notice. Asserting goodwill in the product.
I meant in terms of the characteristics of the product. I mean, William Edge and there's a whole run of case law as to the extent to which you can protect the features of a product through the medium of a passing off action. So, I mean, you talked about no talk to copying, and that's absolutely right. And there's the famous case of the Roho cushion, where an attempt was made to say, well, we have goodwill in the shape of the cushion, to which the answer was, well, not established on the facts, but in any event, not legally sustainable either. But the boundary between what is protectable and what is not protectable is quite contested. But we don't need to get into that, do we?
Well, my lord, just on the point 3 of my learned friend's respondent's notice grounds, he says he ought to have found that goodwill was associated with the elixir serum product and or the respondent as the originator. So there are 2 separate things there. One is the product, and I say that you can't have goodwill in a product per se. If you want to go there on a different case, then you would have to identify characteristics that are distinguishing. And that's not this case. Certainly not how it was pleaded or argued. So to conclude my ground one, I would invite the court to allow the appeal on that ground. If I assist the court further, I'll move on to ground two. Building behind schedule, I'm sorry. This is misrepresentation, and I just want to take the court to page 81 to look at two facts of common ground, which unfortunately didn't make it into the judgment.
Where are we looking?
81 in tab, the chronology tab, tab 9. The two facts of common ground I invite you to look at, the one that's 2016 and March 2017. So on the first one, it was common ground that Ms McIver, Ms Diamond, was experimenting with skincare treatments to find a formula that worked for her before she bought anything from Ms Tang. And the second point is that her first order of serum was for use in her treatments, not as a treatment, but in her treatments. It was also common ground, although it's not stated in terms here, that she had a salon where she did treatments, and you can see that from just over the page, October 2017. It refers to her salon. But if we go to paragraph 9 of the judgment, where this is dealt with on page 94 in tab 11, it doesn't mention that she was experimenting, that was common ground she was experimenting with treatments, or that she had a salon, or that she was using it in her treatment.
Well, can I be clear? Are you attacking the judge's findings of fact? Because certainly I haven't understood that to be advanced in the grounds.
I'm not. I'm simply saying that it's not there. But when we come to consider the representations, some of the representations are about what Ms Diamond did when she was experimenting. It is complained of that she was experimenting, and it was common ground that at least one point in time she was. But it's not referred to in the judgment.
Sorry, the 2016 chronology.
Yes.
As far as I read that, if she was experimenting as for herself personally, not with any view of producing a product or selling a product, it was simply, as you say, within her treatment, she was looking for something that would make her horrible skin irritation feel better.
Yes, my lady. But a lot of the alleged misrepresentations referred to her experimenting and creating treatments for her skin, and that is said to be part of the misrepresentation, when it was common ground that she had at one point been doing that.
Can we just jump to exactly what the judge found to be misrepresentation? Okay. This is the 6th of June. This is the 6th of June 2018 post.
Yes. So just going straight to paragraph 58 of the judgment on page 103.
Well, just before we get there, my lord's drawn attention to the 6th of June 2018, and the judge's finding of fact in paragraph 18 was that it was not true, and that finding of fact has not been challenged by you.
You concentrate, I'm sure we can look at it, you concentrate on the first bit of the 6th of June 2018 post. But what the judge is doing is looking at the whole of it and saying, while she may well have the painful difficulties and constant therapy accurate, what he concentrated on was her story of being driven to create this serum to cure her bad skin, and that was not true. And that's you can read that in the 6th of June post. So what's the problem?
My lord, I'm now looking at two parts of the judgment. Firstly, I do challenge the finding, but it's because it cross-refers in paragraph 58, it goes back to that post.
So can just while we're still, I'm getting confused.
Sorry.
Good.
My fault.
No, not at all. It is complicated, but the point I was making, by which I would like you to help me with by reference to the chronology, is in this post of the 6th of June, as the judge refers to her story of being driven to create a serum. And the point I was simply asking your help with was the 2016 agreed record talks to her experimenting with skincare treatments, namely things that already exist. I'm going to try this, I'm going to try that. So I'm just not understanding why the judge is finding in relation to creating, actually, making a potion, experimenting with all the different ingredients and coming up with something that worked, is inconsistent with several years earlier her going into a well-known chemist and trying 4 different expensive skin products to see if they would help. I just don't see why the judge's finding was inconsistent with the finding in the chronology at 2016.
Could you possibly have a look at the 6th of June
Yes,
post in its original form? Because to my way of thinking, as my lady has just demonstrated, we're dancing around the central finding. He looks at this. My recollection is, and you'll when you look at it, you can see the post covers more than one thing. But what he finds essentially to be a misrepresentation is the suggestion that she had created the cure. So, but again, I may be confused.
Yes, my lord, I'll go to the post, which is it's in tab 15. And
Thank you.
That contains all of the posts and contains all the patients. And the relevant one, the 6th of June 2018, is on page 200 to 201.
Sorry, 200 and...
200 to 201.
Thank you.
So the bit that the judge was talking about, or seemed to have been talking about, in paragraph 58 of the judgment.
Sorry, can we just find the relevant extract in the actual post itself?
It's just above the second hole punch starts.
Right, now that's helpful, thank you. But can I go back to the question I was asking before, because I'm a little puzzled. What I was asking you before was that I had not understood from your grounds of appeal or your skeleton argument that you challenged the judge's finding of fact in paragraph 18 of his judgment. And of course, if you were trying to challenge that finding of fact, you would have all the obvious difficulties. But then there's a different question, which is what I had understood you to be arguing in your grounds of appeal and skeleton argument, namely as to whether there was a relevant misrepresentation having regard to the pleaded case of misrepresentation and having regard to what you say is the necessary nexus with the goodwill. Now, have I misunderstood?
My Lord, I am challenging the finding, and I'm challenging because paragraph 58 is specifically talking about that
Well, you keep on talking about paragraph 58. We'll come on to that. But do I understand from your the answer you've just given me that you are challenging the finding of fact in paragraph 18?
I will go to paragraph 18, my Lord, forgive me. You say that that is wrong. I say by reference to the common ground that she had been looking.
I'm sorry,
That's
can
not
I
the
go
point.
back? That's exactly the point. I hope I've
That's not the point. The point is, did she, in this post, assert that she had created the serum? The judge held that when you read the 6th of June post as a whole, that's clearly what she's saying, and it wasn't true. Doesn't matter that she'd started doing her own little bits and pieces as recorded in the chronology that you've taken us to. She may have done.
My Lord, if we go to the post,
I'm looking at it.
I'm grateful.
Page 200, 201.
Because what it actually says about putting her life and soul into things is not about the serum.
Researching and training, creating and bespoke treatment, tailor-making the ingredients, talking about
And then you get to the Kate McIver serum was designed to my eyes,
Yes,
to turn my skin around and help myself. But isn't she saying she has designed the Kate McIver serum, which was the judge found was a reference to Ms Tang's formulation?
my Lord, I may have got this wrong and talking across purposes. My appeal is against 58, which refers back to the post. If I turn to page to that paragraph.
right.
It starts off.
So that is the judge effectively rehearsing at this stage of the judgment, which is into the discussion part of the judgment, his earlier finding of fact at paragraph 18.
I will leave that point there, and I say in any event that as a matter of misrepresentation to the relevant consumer, it would not be understood what was written there that she was the chemical deviser of the serum, and that's the appeal I put out.
That's fine, but can we just clarify, my Lord, or Justice Arnold's question? Are you challenging the judge's finding of fact that this post misrepresented that she had designed the serum, which was not true? Full stop. Are you challenging that finding?
I think I need to be careful there, because there's the judge's finding that we just looked at, but then misrepresentation has a specific meaning in this context. So I'm not challenging what the judge said at paragraph 18, but I am challenging that it is a relevant misrepresentation.
Right.
My Lord Justice Arnold said that earlier, and I think I've taken us round the houses. I do apologise.
So you're not challenging the finding at 18 as rehearsed again by the judge at 58.
Yes.
What you're saying is that he made an improper, he then went on to a wrong conclusion,
Yes.
because that finding could not properly amount to a misrepresentation.
Yes, because that was a judge's analysis, which had been done with competing arguments either way, with evidence over a period of about a day, and with time to reflect on it. Whereas what is important is what a consumer who is looking at that post thinks. And what is important in my submission is that they will think of it in terms of the brand rather than that Ms McIver was the chemical deviser of the serum. I would also observe, and I've come away from my note a bit, and I'm sorry, but the finding at 58 is in respect of a post where there were a lot of posts pleaded and a lot of newspaper reports pleaded. And the judge invited my learned friend to stick to his top 5, and this was not one of them. Now, I directed my submissions at the top 5, and I wasn't invited to talk about this particular post. So just to go to the pleadings, because again, my submission is that the case that the judge accepted wasn't there, and he also got it wrong. So paragraphs 4, little Roman 4 and little Roman 5 of 25 on 116.
Could you give the page reference just once more?
116, my lord.
Thanks so much.
Tab 12. So we have little Roman 4, which is about the originator of the serum.
And do you accept that the post that we've just been looking at is one of those listed in YNNY 6?
It is, yes. It wasn't one of the top 5. And I say I should have been invited to comment on this between closing and judgment, but I was not, and not particularly fair, but there we are. The 5 that I was invited to comment on were item 6 in YNNY 6, which is what's called the My Mum post on page 203. What was dealt with was the first 2 lines of that, and the rest of the post was left out of both the judgment and the item at the back. And in my submission, if this is read properly, again, it wouldn't be determined to be a representation about who was the chemical deviser. And also, it seems that from the third line,
making up the serum in my back room at home.
Yes, my lord. If we read the next 2 lines, she's talking about a combo of the right products, and so that goes back to what I say is the common ground about her mixing up treatments. She had a salon where she treated people. But in my submission, in any event, the person who's looking at this on Instagram, or Facebook perhaps, in my submission would not take that as her being the chemical deviser.
Thank you.
The second one was a post called item called the Danielle Lloyd post, which is on page 199. The bit that was quoted out of the rest of it was about halfway down. It's highlighted on there. It wasn't on the original one. Created by stage 4 cancer thriver Kate McIver. In my submission, this is about the brand. It's about the feeling. It's about the sort of je ne sais quoi that turns a liquid in a bottle to a premium product. These are the submissions I made at the time to the judge, but they don't seem to have been dealt with in the judgment.
Well, he does deal with these, doesn't he?
Deals with the posts, but not my submissions about what the relevant consumer would take from them.
Well, so the My Mum one he deals with in paragraphs 33 and 34. He says they applied the serum marketing on those dates the same, also not significant. Well, that's more looking forwards in time, I guess. But in the one about we've just looked at, yes, so sorry, it was yes, so and 25 it's also dealt with.
I accept that he refers to the posts, but not what I said about them in terms of misrepresentation.
Okay, thank you.
So that's the first 2 posts. Do you want to take us to the other ones?
Yes, I'm going on the top 5 because they're
Yes,
the ones.
understood.
Yes, item 1 in YNNY 7, which is a quote from a Liverpool Echo article. The article itself starts on page 208. It was dated the 1st of December 2018. By this point in time, this article was part of the launch of the Pelham reformulation. So in my submission, people would understand it to be talking about the new serum, which is a different serum, although I think my learned friend says it's very similar, but it is different. And at this point in time, there's nothing in it which connects the new serum to the old serum. It's not suggested that it's a rebrand of something that was sold before. No, the word elixir isn't mentioned. And again, I made submissions that the reader of this, the potential purchaser, would not understand this article to mean that she was the divider of the chemical formula. It was about the brand and about the thing that went with it, the premiumness of the product. Again, that wasn't dealt with in the judgment. And then on 207, the last of the top 5.
Underneath the photograph, it says creator of the secret weapon. And her quote is, I know about agreements and once I created the serum.
But by this point, she has created a serum, my lady.
But then she refers back further on in the article to how it originated. It's gone beyond anything I could imagine. It was only meant to be something that helped me. Anyway, you think that she's talking about a brand and that...
Yes, and that's how it would be taken. And the final of the
3.
top, forgive me, my lady.
That was number 3. Next.
Oh yes, number 4 is an interview with Ladies of Liverpool podcast, which was item number 7 in YNNY 7, and at page, the text cut out of it is at page 207. go to the transcript, because this is from a long interview that took place on the 1st of March 2019, again when she had her product by this point. In fact, page 248 of the bundle is where the transcript starts. And then you have to go down another 13 pages to select the very short passage of text that my learned friend relies on page 261. So the quote it's about just after halfway down, Leanne Campbell and the background, going down to Catherine Orr, yeah. So the quote isn't quite accurate. All of the words that are said to be misrepresentations come from a third party. And while it is agreed with, in my submission, a person listening to this podcast, hearing this few seconds in the middle of a very, very long transcript, it just simply would not take it in the way that my learned friend put it forward, in that Kate was the deviser of the chemical formula of the product. Now again, these submissions are submissions I made to the judge, and they're not dealt with in the judgment. The final of the top 5 was a Daily Mail article, which was dated the 24th of March 2019. Unfortunately, and entirely coincidentally, that was the date of Ms McIver's death, Ms McIver's death. And that can be found on page 207. Is the extraction from it. Forgive me, 206, item 3. The difficulty with this is at some point there must have been a time where Ms McIver didn't know of any products. So in my submission, the first two lines are what the journalist has said, as is the second, and then there's the quote, but it doesn't say when she's talking about. And in any event, in my submission, taking it as a whole, the same arguments were made, and I make them again, that a person reading this isn't going to think that what she's talking about is that she created the remedy. It's that it's about the brand and selecting it and putting it together. And again, those submissions were not dealt with in the judgment. Just to go back briefly to the judgment, the representations the judge referred to in paragraph 58. Already made submissions on the 6th of June post, but then he relies on an 8th of June and a 1st of October 2018 post. And the 1st of October 2018 wasn't one of the top 5, and it wasn't even pleaded as far as I can tell. The 8th of June one, I think, was pleaded but wasn't one of the top 5. Yes, that's right. And the 1st of Echo, the Liverpool Echo one was one pleaded in one of the top 5, but in my submission it wouldn't be received that way. And then the radio interview was not one of the top 5. So again, I didn't deal with the ones that weren't the top 5, and nobody invited my submissions between closing and judgment, and I say that was unfair. I think I've made observations on my learned on the
Say procedural irregularity you rely on.
Yes, my lord.
You didn't make specific submissions about each and every one of the posts.
Yes,
although they were in the bundle.
And when it should have, what should have happened is if the judge had thought, actually, there's something in other than the top 5, there should have been a letter to council to invite submissions about the.
Right, now where we've got to. That's ground 2, is it?
Yes, that's ground 2. And ground 3 damage can be taken relatively shortly. But the judge rejected any idea of there being a loss of sale.
I'm very sorry, my hearing's not very good.
Oh, I'm terribly sorry, my lord.
A couple of notches.
Yes, sorry, I have a slight sore throat, but I'm trying to keep it up. I will do my best. Forgive me.
Right, so ground 3.
Yes, so paragraph 64 of the judgment, which is on page.
Yes. Loss of sales not proved.
Yes, but then the judge goes on to say that there are two possibilities of damage under reputation.
Mm-hmm.
Now I say that just can't logically be right. In paragraph 65, what is said to be the two possibilities of damage are firstly that the reputation of the claimant, the respondent, is in our hands, and secondly, genericism. The first one doesn't work because for there to be passing off, there has to have been a deception which has led the consumer to believe, given the misrepresentations alleged, that Kate McIver and the appellant are the only source of this product. They were the creator, they made it. That's the nature of the case. So anyone who has been deceived in that manner, if they then see a quality problem or a reputation problem, of necessity will come to us. They can't go to the respondent because otherwise they haven't been deceived. So it's a causation problem, a very big causation problem in my submission, and one that is insurmountable. And the second element of damage, genericism, in my submission, is just simply not logically possible for someone using secret weapon original, Kate McIver, any of the labels we've looked at, any of the brands that the appellant uses to render a completely different mark generic, particularly in circumstances where, one, the people who are looking at those marks on the hypothesis of misrepresentation do not associate them. That is the essential element of the case. There is no association between what we're doing and the brand elixir and the product. So in my submission, genericism doesn't run either. My learned friend's respondent's notice, ground 4, which is on page 49, says that there was damage to the goodwill in a different way. Because he says the judge erred in law and fact by failing to find that the passing off enabled the first appellant to withdraw its own purchases. There are two difficulties with that in my submission. Well, there are three. The first is I think that would be an appeal against the finding of fact, because the judge did say there was no lost sales in the paragraph we just looked at, and he didn't distinguish the sales of one party or another. Secondly, in my submission, it's not potentially damage caused by the deception, because the only person who could have been deceived on this hypothesis to move the sales is Ms McIver herself. It has to deceive relevant consumers.
Could you say that again?
And the person who would have to be deceived in order to damage the goodwill in this way would be Ms McIver herself, because she is the one, or the company is the one, that moved from A to B, from the respondent to the new producer. And finally,
I've got two questions which
yes, my lord.
are bugging me. One is, why can't the judge find damage on an equivalent basis to Dorney the Dorney case, where the second limb which is treated as damage in Dorney, is lack of control of what they're doing, lack of reputation. You'll have the passage better in mind than I do. That's my first question. And secondly, if the judge is right in saying that your client's misrepresentations were with a view to good marketing for her, then why can't this misrepresentation cause loss of sales to Ms Tang, at least after you've got your own serum which you're not buying from her?
The first point, my lord, is that I thought I said it, but
You probably did.
if it's about reputation and losing control of reputation, because of the nature of the deception talked about in the respondent's case, anybody who was deceived would not know about Ms Tang by necessity. They would not understand her to have the reputation, to have be the creator. So if they were deceived, they wouldn't be throwing reputation problems back on Ms Tang. They would have to come on the appellant.
But you are by now in competition with Ms Tang, but on this hypothesis, once you stop making alternative purchases, you're in competition with her. Why is it not to be inferred that if you pursue this marketing device that you are the originator of the formula, that will benefit you in your competition with her, and an inference that there may be loss of sales?
Well, I would say that the judge didn't find those loss of sales, and he found
No,
those.
he didn't, but I'm just trying to work out why.
Because firstly, gain to the appellant is not part of the test. That's a restitutionary claim, but in tort, it's about damage to the claimant, the respondent. So that the two are not synonymous, and the evidence was that during the period where they were together, even when these misrepresentations were allegedly operative, there was a huge uplift in Ms Tang's sales. So that's, I think, why the judge came to that conclusion.
And after you started using the Pelham formulations,
There was no evidence of any lost sales. And
by Ms Tang.
yes, and that is my next point on causation, which is that the misrepresentation has to cause the loss. And the way my learned friend is putting it in his respondent's notice is that the misrepresentations have caused us to move. But that is not how it was said at the time. What was said at the time was that Ms Tang had kept increasing her prices and they were too expensive. And there were second reasons about quality, which we don't need to go into any depth in the papers. And they were the reasons given. And it was not challenged that that was false, that actually they left for different reasons. So, but for the misrepresentations, the appellant would have left anyway.
Right. I'm
So-
conscious of time.
Yes, my lady. Those are my submissions on ground 3.
Yes.
On copyright infringement, I've set out. If we go to the pleadings, and page 117 in tab 12.
Thank you.
The relevant paragraph is paragraph 26. It sets out the copyright infringement case. Little Roman 1 is ownership. Little Roman 1A, sorry, also ownership. Little Roman 2, assignment leading to ownership. And then we get the alleged infringements. Contrary to section 17 of the CDPA, the first defendant, Ms Diamond, have in material form copied the copyright materials with their own marketing materials, the infringing materials. And the schedule is set out in YNNY 10. And I'll go to that in a moment. But in Little Roman 4, contrary to section 17 of the CDPA, which almost certainly must mean 18, because section 18 is the one that deals with issue of copies to the public rather than section 17. And then contrary to section 23, which is a secondary infringement. Now, just on the pleadings, there is no plea of any infringement contrary to section 18, which is the communication right.
You mean section 20?
Just forgive me, yes, section 20. I apologise, my lord, yes, which is the communication right. And the plea under section 23, there is no plea that there is an article or that there is any knowledge or reason to believe. And the plea of knowledge has to be particularised fully. Now, the materials at YNNY 9.
Well, on that last point, that seems to be a submission that the plea was strikeable, but there was no application to strike it out.
There was no application to strike it out because the answer to well, I think there was an application to strike something out, but I wasn't involved back then. The answer that was given was that these acts were licensed in any event. So if I go to the defence now, the plea back to 26 is set out 40 on page 129. And the answer was that there was a license. There's a general denial, paragraph 40. And then there's some facts which set out 44 down to 46. Which set out the reason why we said there was a license. And then 47 is also the conclusion that there was a license. And in reply, which starts at page 141, paragraph 33,
Do you mean paragraph 33?
it starts 33 and goes down to 40 to paragraph 40 on page 141.
Okay, I was thinking.
Relevant passages are 39 and 40, which give the conclusions. Simply says no consent was requested, none was provided, and then paragraph 47 is denied, and that's the allegation of license. So there's no alternative case saying in the alternative the license ended and therefore you are now infringing. There's no plea of continuing infringement or anything like that.
Thank you.
The judge found that there was a license until November.
30th of November, yeah.
Yes. So in my submission, it wasn't open to the judge to find that there was continuing infringement when it hadn't been pleaded that there was continuing infringement. There's been no inquiry because of the way, forgive me, my lord.
I was just thinking that there's no, is the original allegation in the particulars of claim time limited?
Well, it's not time limited, my lord, but the Copyright Designs and Patents Act is restrictive of acts. It talks about the exclusive acts of the copyright owner. So there has to be an act. And in my submission, those acts, so the acts of the actual copying under section 17, and the acts of, to the extent that they were issued copies of the public, I'm not sure that that is actually made out on the evidence, because that's about tangible articles rather than things on websites. So those acts occurred when they were licensed. And then the question is, well, what happens at the end of the license? But there was no set of facts which would allow anyone to investigate what happened at the end of the license. The common law position would be one of two things. It would either be that there was a reasonable notice period to take it down, because it's not that the license ends and that's immediate, or they were to be taken down on demand, or perhaps that the Licensed Act were just continuingly licensed. But there's nothing in the pleading that sets that out. And when one looks at where the infringements are alleged to be, they're all online. So they start on page 302. Oh no, they don't. Forgive me. That was they were the extracts from the claimant's website that caused a lot of confusion at trial. They go from 308 down to 317. And they're all online.
Mm-hmm.
So whilst I accepted at trial that the text of one infringed the text of the other, I didn't accept that for all purposes and whatever my learned friend wanted to say, there was a copyright infringement. He still had to prove the relevant facts. Online in my submission is section 20, and it's not even in the pleading.
Yes, thank you.
So I think I've dealt with all of my learned friend's points going along. So unless I can assist the court further, those are my submissions. I've had one point drawn to my attention by my instructor sister. It's a good point. In terms of Bristol Conservatories, and I say the facts are different because of the white label relationship. There was no such thing in Bristol Conservatories, and in fact, the claimant salesman went off and joined the defendant with this thing of photos in his hand. There was never a consent period, which in my submission changes the dynamic.
Thank you. Anything else? Thank you very much indeed. Yes.
My lady, my lords. As with my learned friend's structure, I intend to split out the passing off for the copyright. I'll do the copyright at the end.
And unless you've got a cold too, could you keep your voice?
I'll do my best. Yes, my lord. Turning to passing off first, going to the judgment of the learned judge at tab 12 of the core, tab 11 of the core bundle. Get my lords there. Page 99 of the bundle. We see in paragraph 46 the learned judge's legal reasoning, and the starting point of paragraph 46 is reference to Lord Oliver's judgment in Reckitt. Apologies that my skeleton argument refers to it as Lord Bridge's judgment. There is an error there, and all references in my skeleton to Lord Bridge ought to be to Lord Oliver. Now, there's also at paragraph 49 reference to Lord Diplock's judgment in warning and the 5-stage test, and the judge found that both tests were fulfilled. There is a difficulty in this case because in my submission, Reckitt was never the appropriate test to be applied. It plainly, and I'm going to go through some of the authorities, so I hope to support this proposition, but it plainly is a case to be seen in its context, which is a case on misrepresentation by utilising a brand name or by utilising GetUp, but that does not exhaust by any means the categories of misrepresentation that may arise for the purposes of passing off. And so I fear that my learned friend's skeleton argument for the trial, which introduced the test in Reckitt, was perhaps the basis upon which it ends up in the learned judge's judgment, and the learned judge frames the judgment as having to fulfil that test, as well as legitimately fulfilling the 5-step test in Lord Diplock's judgment. But realistically, in my submission, that isn't the appropriate test at 46 of the judgment, and the appropriate test is actually set out at 49, and the learned judge finds on both tests that the case is made out. Now, the theme, there are a number of themes that arise from the cases that have been referred to my lady, my lords. In relation to goodwill, it's plain that it's established by trade and custom. There's no need for a brand or get-up, and it's perfectly acceptable to demonstrate goodwill referable to somebody being the commercial source or originator, as it's been phrased in this case. And in fact, in the ScanSafe case, the origin and originator, but for today's purpose, I say that they effectively have the same meaning as commercial source, which is the phraseology in Bristol Conservatories. But there's no need to demonstrate the use of a brand name or get-up for the purpose of misrepresentation, and therefore there's no need to show it in relation to goodwill. So those are some of the themes that come up from the case law in relation to goodwill. On misrepresentation, a misrepresentation may be express or it may be implied. Now, an express misrepresentation may be an out-and-out lie. One might say, these goods are the goods of another. So that would be an out-and-out lie. Whereas an implied misrepresentation, such as get-up or brand name, those are referred to in the case law as implied misrepresentations. And in those circumstances, one then needs to start engaging perhaps in elements of whether there's confusion, whether what the relevant public, any attributes of the relevant public that would make them more or less likely to be misled by the representation. And ideas along the lines of descriptive marks, or as my learned friend says, a generic mark. It's important as well to note that the misrepresentation is not a closed shop. It really is a test that would be met on any given facts of a particular case. And my lady, my lords will see through the case law that the misrepresentations are different in different cases, and I've referred to 4 cases, including Bristol Conservatories and ScanSafe, where the types of misrepresentations are not in line with the branding and get-up. And there are plenty of instances of wider application. There's a point raised on reverse passing off, which is curious terminology, I suppose. And when I come to Bristol Conservatories, it will be seen that really reverse passing off is a form of phraseology, but actually the question is, do the facts in question fulfil the test for passing off? It's not really a separate tort. It's not to be regarded as a separate tort. I agree with my learned friends that there is no monopoly to be had in goods, and that Ms McIver could perfectly happily have produced exactly the same liquid in a bottle and have sold it. That isn't the problem. What she couldn't do is she couldn't go about selling it and marketing it in a way that created the misrepresentation as to the commercial origin of the product. And that is what she did do. She laid claim to being the creator, and then effectively the commercial origin, and then she managed I suppose the idea is that by the seamless transition to the new product, without anything there to inform her customers that she had changed to a new manufacturer, that this was no longer the elixir serum that they'd been buying, or it wasn't from the same source, there becomes an automatic misrepresentation. I say that's the sort of rationale that the learned judge followed. In relation to damage, the themes that come out of some of the case law are ideas like taking credit for another person's product, stealing reputation, taking the reputation in the hands of another, and denigration of the brand or, I say, product. I can see that my ladies and my lords have been through much of the case law, and I don't want to spend an awful lot of time going through it if that's not helpful to
I
the
really
court.
don't think it's necessary, Richard.
No.
Not unless there are any very specific passages that you want to draw to our attention.
I suspect that if I were to embark upon the task, I'd probably, my skeleton argument largely sets out the passages in detail. So
you're
really do
entitled to say you rely on the passages you set out in your skeleton.
my skeleton argument.
Fine, thank you.
Yes, and you've helpfully specifically identified authorities as a separate section of the skeleton argument, starting at paragraph 27, which is very useful. Thank you. Once we know Lord Bridge is not Lord Bridge.
I ought to deal with the pleading point.
Yes, please do.
So, take my lady, my lords, to page 115 behind tab 12. I note that in ScanSafe, Mr. Justice Patton, as he then was, noted this as a difficult area of law, and I would say that whilst the threads have been pulled together, I hope sufficiently in my skeleton argument to establish the course of action that are relied upon. It is a relatively complex cause of action in a sense that it's a bit underdeveloped in the case law, I suppose is how I would put it. And what the approach that has been taken with the pleading is to attempt to marry up the pleading with the ScanSafe decision and with the Bristol Conservatory's decision. And hence why they're specifically referenced, and to the extent that argument ought to be pleaded, in my submission it there has. It is important to note that in terms of supporting the learned judge's decision that there is an association of goodwill with the Elixir brand, both of the paragraphs 25 Roman 1 and 25 Roman 2 do state by reference to the foregoing, and there is a substantial amount of pleading regarding the sales of the Elixir serum, both to Ms McIver and to third parties. And at paragraph 14, the total combined sales for both Ms Tang and the claimant are set out there at 155,000. That was July 2019. There is also set out from paragraph 15 through to paragraph 20 the sales of serum to Ms McIver and or the company. And clearly, there was the serum had been branded as Elixir serum by the respondents, but also it's noted that in the list of Kate McIver secret weapon, the first label and the second label, the first label actually has the name Elixir on it, and so to the extent that the learned judge finds that there is goodwill in the name Elixir. Certainly on a pleading basis, he was entitled to come to that decision, considering that the first label was pleaded as one of the list of items. Now, so Roman 1 is trying to get at the idea of the product of the goodwill being associated with this, as I described at trial, the liquid in the bottle. It's a distinctive product. It was marketed by Ms McIver as a distinctive product, and plainly has a repute in the eyes of the users. This Roman 2, I don't agree with my learned friend's analysis of this exactly. It actually says that the claimant is the owner of valuable goodwill as the originator of the elixir serum, and the important was supplied to the first defendant under those unregistered trademarks. Because the bottles that were sent through had the labels on them, and they were supplied with the trademarks, unregistered trademarks attached. And to the extent there was any doubt about the pleading, and there was a strikeout application early on because it was said that no cause of action was properly pleaded, and in avoidance of that as such, there was an amendment which then features at Roman 2A, and it was made express that the basis of claim was by reference to Bristol Conservatories and ScanSafe. So in my submission, the pleading there is perfectly adequate to establish goodwill. The trade is set out, and to the extent that there needs to be an association, I don't say there does need to be an association, but to the extent that there does, that association is set out there. I say there doesn't need to be an association, really because Ms Tang and then the company are the originator of the product, whether or not people know that. And the case law makes plain for example, in Plomian, I believe I have quoted this part in my skeleton argument. It is quite sufficient, in my opinion, to constitute passing off in fact if a person being minded to obtain goods which are identified in his mind as a commercial source is led by false statements to accept goods coming from a different commercial source. Turning to the pleading on misrepresentation, I have to confess I hadn't understood my learned friend's skeleton argument in terms of whether there was an attack on the factual findings of the judge. I had read his repetition of the factual arguments that he made before the judge as being an attack on the factual findings. It appears today that isn't framed now as an attack on the factual findings.
He distinguished eventually between the facts found at paragraph 18 and the judge's analysis of the message conveyed to the consumers by the relevant posts at paragraph 58 and following.
All of this comes down to confusion, which when dealing with misrepresentation, what my learned friend effectively is trying to say is that he says that the judge should have identified the relevant public and then looked at how the statements would have been interpreted or taken by the relevant public and whether that would have been liable to cause confusion. The problem is with that approach, that may be the case where one hasn't got an express misrepresentation, where it's not clear cut, but one can see from the wording of the statements made, which my learned friend has largely been through and are set out in my skeleton and variously in the annexes to the particulars of claim. One can see there isn't any room for confusion. I'm not sure the attribute that my learned friend would seek to attribute to the people who are likely to buy this product. Apologies. William Edge, which was the blue dolly case with the handle on the cloth bag. In that case, it was said that the I'll just go to the judgment on that. Apologies. So it's in it's tab 2 of the authorities bundle.
William Edge, did you say?
Yes.
Tab 2.
Tab 2. And it's page 39 of the authorities bundle. It was interesting in this case that no branding had been attached to the plaintiff's blue dolly bag, or dolly blue bag, I should say. No branding had been attached, but then when the passing off occurred, labelling had been attached, and it almost appeared that they were branding it for the first time. So anybody who previously bought it would have assumed that it was the new seller that had put some branding on, but assumed it was the original producer. But when we look at the issue regarding confusion and the relevant public, it's clear at the top of 705 here, the poorer classes who buy this class of good do not seem to distinguish the goods by this label, but by the general appearance which the articles present. I mean, it might have been that at the time people wouldn't have been able to read the label and discover the branding, particularly the likely people who were going to be buying the product. When going on to wreck it, who were the relevant public in that case? It was said to be housewives who were busy in a supermarket and wouldn't take the time to be distinguishing between the two products, because the law lords in that case were surprised that people wouldn't recognise the difference between the two products, having them in front of them. But if my learned friend wants to say that this...
That's a slight misstatement. So to be clear, the plastic lemons were indistinguishable pretty much. The differences lay in the paper labels attached to the plastic lemons. And any careful purchaser who read the defendant's label would appreciate that it was not the GIF product, albeit I emphasize the word careful, because the defendants created a real problem for themselves by using a descriptive brand name themselves. If they used a distinctive brand name, they might have had less problem. But in any event, that's speculation, because what the evidence showed was that people just never read the paper labels. They picked up a plastic lemon and said, aha, I've got a GIF lemon.
And that comes down to the attribute of the people who are purchasing. And my learned friend hasn't identified any attribute of somebody purchasing this serum that would suggest that they wouldn't have been misled by the very clear statements that were made. And so really it is a wild goose chase in my submission to be going down the rabbit warren of working out whether there was who the relevant public were, how they would appreciate the statement, whether they would be confused. There is no room for confusion. And that is exactly what the learned judge found. In fact, he found there was no room for confusion to the degree that even Ms McIver can't have believed what she was saying. He found that she was malicious in making the statements. So, going back to the pleading at 116, it really is fair to say that the pleading is tied in to the Bristol Conservatory's type analysis as to the origin of as to the claimant being the originator of the product. There's the misrepresentations regarding Ms McIver saying that she created the product, the misrepresentations by utilising this, what I describe as the seamless transition, by utilising the same trademarks to sell goods from two different originators. There's a misrepresentation. She could have avoided it, of course. What she could have done is marked up the product, had an advertising campaign, something to say, this isn't the same product. She would have always been in difficulty though, because she'd laid claim to bring the creator of the product. So she couldn't really take the step that would have been necessary to avoid the misrepresentation, because it would have screwed up the whole marketing plan that she'd devised. And also the idea of harking back to this word of original, especially when there were complaints about the limited edition, she harks back to the word original, which in the judge's findings was effectively saying that it was the elixir serum. In my submission, when it comes to the pleading on goodwill and misrepresentation, they can't, read in the whole, in the round and as a whole, there can't be any true criticism. In terms of damage, it is said that there was an impeding of the ability of the claimant, Ms Tang, to take recognition for the elixir serum and to build her brand by reference to that recognition. Now, I say this is what led the learned judge to make findings on damage in terms of the reputational damage. And I have in my skeleton argument referred to Dawny Day, Clomian, and Ewing at paragraph 77 to 79. It's at pages 68 and 69.
Twenty-seven to 29.
77 to, sorry, apologies, 77 to 20 to 79. There is set out the paragraph from Dawny Day, which the learned judge himself referred to. But the Plomian decision is interesting on damage also, and Plomian is of a similar nature to this case. I mean, there is one very stark similarity between this case and Plomian, and that is that test results and for a celebrity client of Ms McIver's, that is Danielle Lloyd, her before and after photographs utilising the Ms Tang's product were utilised then for the marketing for the reformulations.
My lady, my lords, that was not one of the pleaded misrepresentations. The post, some words from one of the posts was used, but there was no reference to before and after photographs. It's too late for my learned friend to take that point now.
Well, it is referred to in the judgment, and it was within the totality of the evidence that the judge had before him, he was entitled to have regard to all of the misrepresentations that were evidenced, whilst he had to find the case, make a finding as to whether the pleaded case were established. There were ample other examples, and that it was a continuing passing off over a significant period of time. I mean, the learned judge said until at least March 2019, but there's evidence of reposts of before and after photographs for various, I think there are five different persons that I could take the court to, and they're referred to in my skeleton argument for the trial. So it really is in some ways on all fours with Plomian in that regard. And just to refer to the fact that these persons have purchased the product, a celebrity, for example, is again on all fours with Plomian, because they were referencing, in that case, the defendant had been referencing both the test results and the purchasers.
Voice is
sorry,
dropping.
had been referencing both the test results and the purchase and the identity of the purchasers, or some of the purchasers. So in Plomian, it was said, I cannot myself see that there is anything improper in the court when it finds a deliberate attempt to deceive and to steal the benefit of another trader's reputation. And it's that's what passing off is all about. Stealing the reputation, and that's exactly what has happened in this case. if Ms McIver didn't think that there was some benefit to be achieved by this strategy, by laying claim to be the creator of the product, if there wasn't some value in being the creator of the product and the originator of the product, she wouldn't have gone about the nefarious purpose. And there obviously was a utility to it because it was all over the Liverpool Echo, the Daily Mail, all over Instagram. I should say there are better copies of the Liverpool Echo and the Daily Mail articles in the supplemental bundle. Just give the page references in case that's helpful. They read in a much better way. It's at page 397 and at page 430. Now, to the extent that the court needs to make a finding that the passing off is capable of protecting goodwill in circumstances where the misrepresentation is the reverse way round, that is, that the defendant misrepresents the claimant's goods as the defendant's goods. In my submission, that finding can be made by reference to particularly the decision in Spalding, and that in that case it was actually the defendant was misrepresenting the claimant's own goods as simply a different version of the claimant's own goods. So they weren't representing the defendant's goods as the claimant's goods as a normal passing off case. They were representing the claimant's goods of a different class. And if anything, I would suggest that a reverse passing off where the defendant represents the claimant's goods as its own goods is even closer to the form for passing off. And Spalding is, if anything, a little further away. But all of these cases do fall within that broad definition of Lord Diplock. If my lady, my lords, are not with me on that point, then at least the way in which the misrepresentations were made as to the creation of the product enabled the misrepresentation in relation to what I'd refer to as the seamless transition. So it meant that she could effect a seamless transition from the one product to the other because she'd laid claim to being the creator. My lady, my lords, if I could go to the judgment, the London Judge's judgment at tab 11. So, having set out the law and passing off at paragraphs 46 to 49, and then dealing with the specific instances of Bristol Conservatory and Plomian, the learned judge notes that the facts in this is at page 102 at the top, so at the end of paragraph 52. The facts of both Bristol Conservatories and Plomium fit comfortably into Lord Diplock's 5 requirements in warning. From paragraph 54 is the discussion, and paragraph 55. I am satisfied that her business had acquired goodwill in that period. That's from June 2015 to June 2018. And that is a result of her sale of the serum. And that is an independent finding of goodwill before one goes to paragraph 56 and has to create this association with the trade name Elixir, which, as I say, really does result from the reference to Reckitt as being an appropriate test to be applied.
But the point that's made against you is that when the judge says in the 4th sentence or 3rd sentence of paragraph 56, YNNY's case is that her business and sales of the serum required goodwill, and that goodwill was associated in the public mind with the trade name Elixir. And then he says, I find that case established. The problem with that is that case was never pleaded.
In my submission, the pleadings would cover that analysis because at paragraph 113 of the page 113 of the bundle and paragraph 13 of the particulars of claim. The name Elixir is specifically pleaded, and the paragraphs at 25 Roman 1 and 25 Roman 2 can't be divorced from what goes before and actually specifically reference the foregoing. Now, of course, it wasn't likely that this issue regarding Elixir was ever going to reach the list of issues for determination by the court in circumstances where it was plain for all to see on the bottles that she'd been selling it under the name Elixir. And not only that, but in the defence, at paragraph 29, it's page 127. It simply said the claimant is unable to admit or deny the facts and matters set out in paragraph 13 and 14. They don't deny the use of Elixir. And in fact, they admit the use of YNNY. At paragraph 25 of the defence, the trading name YNNY is admitted. I do seek to uphold the learned judge's judgment in relation to use of the brand name Elixir, but in my submission, that wasn't a necessary finding for him to come to the conclusion that he came to.
Yeah, and that really takes us to your respondent's note.
It takes us to the respondent's notice. Well, that is my respondent's ground 1, effectively. Respondent's ground 2 deals with YNNY. I'm not sure really that ought to. Well, it may end up proving a distraction. I really have included that in case my lady, my lords, was with my learned friend saying there has to be an association with some trade name. In my submission,
if I may say so, I think you're wise to be cautious about paragraph 2. Paragraph 3 is your better point.
Quite. And so I turn to paragraph 3, which in my submission follows the original pleading, is the correct way of analysing the case, and it flows through all aspects of a claim for passing off, where the claim is effectively based on the being the originator of the product.
Now, would you like to expand on your round 3 of your response notice after the short adjournment? How are we doing for time?
It is 3 minutes past 1. I'm.
No, I meant, sorry, your
Oh,
your
apologies
time,
for-
I could rise now till for the short adjournment, but how are we
How long-
progressing with your submissions? I'm not putting
I
any
would have
pressure on
thought
you.
about 30 minutes at most.
So thank you very much.
Thank you, Madam Chair.
2 o'clock, please.
Court rise if you're able to. Just a gentle